90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the National Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we'll be talking about alternate dispute resolution, sometimes known as ADR, and our guest is a neutral, a person who helps parties resolve dispute as a mediator or arbitrator, and we're pleased to welcome Jennifer Herscovici, and she is a lawyer who acts as a neutral with NAM, National Arbitration and Mediation, with offices in Garden City and Manhattan and elsewhere in New York State. Jennifer, welcome to Law You Should Know.
Hi, Ken. How are you?
I know you practice tort law for the city of New York, and you help settle, you litigated and then helped negotiate and settle thousands of tort cases, and then you used your experience and became a neutral, a mediator, and an arbitrator for National Arbitration and Mediation, and you help parties resolve cases. Why is it easier for plaintiffs and defendants, someone who's been injured in an accident case, to resolve it through mediation with your help?
So, in my opinion, alternative dispute resolution or mediating a case is always the most effective way to resolve a case. It's effective for a number of reasons, but basically, you have control over a case when you mediate the case, and you could get the case resolved in a timely manner. You could get the case resolved soon after the case is brought, or, well before the time of trial. So in my opinion, if you want to effectively resolve your case, you should be mediating it as soon as possible.
Just to bring in the real world into it, if someone has an accident and they litigate it through the courts, it may take years until the case is decided at trial. And then if one party's not happy with the result, it can take years until that case is resolved on appeal, possibly necessitating another trial. And of course, during COVID, the courts were closed. And now that as we emerge from COVID, the courts have a backlog of months and years of cases, so things are even more clogged than before.
That's right. It's my experience that parties want to resolve their cases as soon as possible. So parties don't want to sit with a case for years and years and years. So we've always seen backlogs, and we've always seen that it's taken a lot of time to get to trial. But now with COVID, what happened with the pandemic was that the courts stopped. And NAM, the company that I work for, it didn't skip a beat. It went straight into virtual mediations. And now if you want to mediate your case virtually, you can. And so some mediators like myself, I'm happy to come in and mediate cases in person as well. So we have virtual mediations happening and in-person mediations happening. And you could schedule a mediation within weeks or months of the time that you request the mediation. Whereas with what's happening in the courts are so slow at the moment and the resources are so limited that the type of time necessitated to get a case resolved, whether it's at trial or the court trying to resolve the case before trial, they just don't have the ability to do what you could do in private mediation.
And also the courts are not structured to consider the convenience of the attorneys, the parties, or the witnesses, while with mediation, it's all about convenience.
It's all about convenience. It's all about the informality of it. It's all about the ability to give as much time as necessary to get a case resolved. It's all about control that the parties have over the outcome. And obviously, concessions have to be made when you're trying to resolve a case through mediation. But ultimately, when you do that, it's cost effective and you can move a case rapidly and you know what the final outcome will be.
And it's also about control over the process, because when you're in litigation, a plaintiff, a defendant, their attorneys, an insurance company has no control over the process, or very little, while with ADR or mediation, they have total control over the process in terms of scheduling and maybe the exchange of information, in terms of resolution, in terms of settlement. They have control over everything.
Well, yes, and that's exactly what I mean. When you don't settle a case and you go to trial, you start to lose some control. So once a jury is picked, one party will see that perhaps the jury is not the jury that it was hoping it would have. And at that point, you've now lost the opportunity before the jury is picked to get the case resolved. It may help one party get the case resolved for a better number than it was hoping, but it will certainly hinder the other party. And you never know prior to jury selection which party it will help, because you just don't know what the pool is going to look like.
Some people say it might be Russian roulette. It could be disadvantage to one party. And the other thing is, with traditional litigation in a court, there's usually a winner and a loser, or both parties may be losers. It's very rare that both parties are winners and have control and the ability to accept or reject the resolution as they do with mediation.
I tried numerous cases to verdict. And for as many cases as I tried to verdict, I settled hundreds more, whether it was before jury selection, after jury selection, or during the course of trial. And the jury that's chosen and the judge assignment, when you have a case that gets a judge assignment at the time of trial, and how the evidence goes in, and how a witness testifies at the time of trial. This all plays a part in the value of a case. Sometimes cases become extremely more valuable once you hear from certain parties, and sometimes they become a lot less valuable once you hear from certain parties.
And sometimes it's like a football game. You don't know whether that pass is going to be caught, whether the runner is going to score a touchdown. There's no way of knowing for sure how it's going to go.
And sometimes lawyers are shocked by the outcome that a jury renders. And so, again, by settling a case beforehand and settling a case as early on in the process as possible, you take control over the outcome.
And you're helping each party win, in a sense, and get what they need to resolve the matter. So how does that occur? How do you go about that? You, as the mediator, are overseeing the process. There's no judge or jury. It's you helping the parties to resolve the case. So just tell us about what happens in the process. So
the way that I conduct a mediation is, and this is going to be a long-winded answer, but first of all, when submissions are submitted to me, and we could talk about submissions after, but when submissions are submitted to me, I will read through them and take notes on them. So I know what the case is about prior to walking into the mediation. But despite preparing for the case, I ask the parties to present their case to me. And it doesn't have to be a long-winded presentation, but to present their case to me prior to starting the negotiation process. And there's a number of reasons why I do that. But I think most importantly, it gives the attorney on each side, or on all the sides, the opportunity to showcase the fact that the attorney is prepared for the mediation, and that the attorney is an advocate, an effective advocate for his or her client. And so it also shows me what they're sharing with one another. So usually the submissions are confidential, but then once I hear through the presentation what they're sharing with their adversaries, I know what I could keep to myself and what I could share with one's adversary. So I hear them present their cases. I ask everybody what the last demand was and what the last offer was, because if I split the parties up before getting that on the not on the record, officially on the record, but done, but in front of everybody, then you hear differing accounts when you've split the parties up. And then after hearing the essentials of the case and what the last demand and the last offer was, and a little history, if there is, of the demand and offer, and procedurally where we are in the case, I then split the parties up into separate rooms so that I could speak to them individually.
And I just want to take a moment to remind our listeners that we're talking with Jennifer Herscovici. She's an attorney, and she acts as a mediator and an arbitrator with NAM, that's National Arbitration and Mediation. And she's telling us about how she brings her experiences and skills as a trial lawyer and negotiator to help parties resolve their disputes. So you've set the stage, and I just remind everyone you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College. So you're describing how you bring your skills and your experiences as a litigant. You have all the parties meet together. They share some information. They give what they're looking for, what their concerns are, and then you meet with them privately. And you also preserve their confidences that they give to you in those confidential sessions where you just meet with one party or the other. So what is the dynamic once you have that joint session, individual session? How do you eventually try to bring the parties together, move toward resolution?
Okay, so once you divide the parties up and you start speaking to the parties individually, everybody sort of is a bit more relaxed and becomes more open with the mediator, obviously speaking in if there's confidentiality between the mediator and the parties, and start speaking about where they're looking to go with the case and why they're looking to go in a certain direction. So as the mediator, I kind of get a sense of where the case is going. I use my experience in having, mediated hundreds, thousands of cases before and negotiated hundreds, thousands of cases before. I use my experience as a trial lawyer, and I also use my experience reading the room and figuring out where the case is going and where the case can go and where the case should go. And then I start to work with the parties on getting them to the right place so that the case could be settled. It's different for every case, right? But you have to have a background in knowing where the cases often do settle when you have the different nuances that come up in all of these cases. But then there's also this feeling of where the parties want to go with it. So I read the room, but aside from that, I also work with the clients and get them to a place of understanding that they may value their case in a way and put a certain number on it that they want to settle the case at, or if it's a defendant that they can only get to. And sometimes I agree with them wholeheartedly, but sometimes I think that their analysis is misplaced, and we'll talk about why it's misplaced, and we'll get to a place where they understand that they have to make certain concessions that they may not have considered before the mediation in order to get the case settled.
You're helping to educate them about reality. But it's a conversation. You're not putting handcuffs on them. You're not laying the law down to them. You're just trying to share with them your experience as a litigant, as a settler, and as a mediator. Anybody
could walk out of a mediation at any time. I mean, that's the goal of the mediator, is to get the case settled, and you hope that nobody walks out. But there's, unlike a judge who has a lot of power at the time of trial in making rulings that could really harm one's case, a mediator approaches settlement or negotiation in a much different way and really gets the parties to come together and finds ways to get the parties to come together. I mean, you can't. You're
educating them, and you're working with them on using their power to settle the case. In a court setting, they have no power. The judge has the power. The jury has the power. They have no power. In mediation, they have power, and you're helping them to exercise it wisely.
Absolutely. I couldn't agree more.
And it's a little dance, and it's you're breaking down different issues, and you might get them to agree on one issue and then move on to other issues. Some issues they may be right about, some they may not be right about, and that's true for the other side as well.
And sometimes the lawyers understand what's happening, but the parties need help. So sometimes a plaintiff's attorney will a plaintiff's attorney should always have the plaintiff either available or bring them to the mediation. And I've been asked on numerous occasions to speak to the plaintiff, to explain to the plaintiff why the case is being negotiated, why the offers are being made the way they're being made. And sometimes a party like a plaintiff just needs to hear from a neutral, just needs to know that there's somebody who's heard about their case and empathizes with what has happened to them and speak, and they could see it in your face. They could hear somebody say, I understand that this traumatic event happened to you and that you are looking for some kind of resolution. And there's no amount of money that, that perhaps that can make the difference here. But if you want to get your case resolved, this is the only way that we're going to be able to do it, unless you go to trial. And then you lose full control.
And on the flip side, the defendant may think it's a phony case or a sham, and maybe they thought there was a little tap, and they can't believe the plaintiff is injured or that they needed surgery. And maybe they're right, and maybe they're not. But as you said, you can listen to them. You can have a conversation with them. You can allow each of them and their attorneys to be heard. But that's not going to happen in court. The judge and jury, they're constrained by rules of evidence, and they're not there to listen to people. They're there to follow strict rules about what evidence comes in and what the jury may hear.
Absolutely. And on the flip side, I think that defendants, oftentimes for me, it's insurance companies, the adjusters or some representative needs to hear from me that they may not be valuing the case the way it should be valued, that they're undervaluing the case, or they need to hear from me that oftentimes I'll talk about prior experiences and they may be so focused on one fact or one issue that the plaintiff may have with their case, but they're losing sight of so many other factors that could come in and really affect the outcome of their case. And they could get hit for significantly more than the case can be settled.
So you're trying to educate the parties, too, about reality. And it may be the plaintiff who's always overvalues the case or doesn't realize there could be other factors, or it could be a win-lose scenario.
Absolutely. So I'm educating the lawyers sometimes, the parties often, and sometimes not. Sometimes it's just a dance. And
you want to be educated. You want to listen to their stories, their evidence, their precedents, and you'll take it all in and you'll have a discussion with the parties and the lawyers about it.
Absolutely, because every case is different, and the nuances to every case make a big difference sometimes in how a case should resolve.
And going to court and having a trial, it's not about those conversations. It's not about educating, not about making conversations. It's not about resolving. It's about rules of evidence and procedures and scheduling and expenses and rigidity and uncertainty.
Right. I mean, you take the chance when you go to court, right? There are obviously some judges that are very good at trying to get cases resolved. If you get their attention, ultimately, when the case either is put on their calendar to discuss or when it gets to trial, but a lot of judges don't look at themselves as mediators. They look at themselves as trial judges, and they're there to get the case resolved through a trial, not through mediating the issues.
And even if they're good at that, they have to follow a lot of rules about scheduling and about priority and about interruptions. They're just applying different rules to get to a jury verdict, which neither party may like.
Yes. Oftentimes, obviously, sometimes, there is a party that likes the resolution, but even when you like the resolution, if there's a defense verdict or if the verdict is an incredibly large plaintiff's verdict, then the case is going to sometimes be appealed. And so now you're waiting years on end, potentially, for the resolution of the appeal.
And the victory may be short-lived and it may be uncertain. And meanwhile, expenses continue to mount up for both sides.
Expenses are significant for both sides. And you're also taking the risk that the law is going to potentially change. So you don't want to make bad law in the course of your appeal either. So, which is another reason why a resolution is always.
And the judge may make mistakes in the rules of evidence and different things that neither party has control over, and there could be reversals for those reasons as well.
Oftentimes, when you have a trial, it's inevitable. Mistakes are made. And so, yes, when a verdict is not, when it's significant, where it's a defense verdict and it wasn't expected, or it's a significant plaintiff's verdict, they're appealed.
And even if there are motions before the case gets to trial, so motion during the trial, there can be appeals of those motions, and the process can go on and on.
Absolutely. And if you try to get your case resolved during the pretrial phase of litigation, you also take the risk of a motion for summary judgment being made. Obviously, we know the cases where the motions for summary judgment won't be granted. I mean, it's very rare in most types of cases that a motion for summary judgment will be granted. But there's reasons on both sides, or on all the sides, for why you want to get a case settled as early on in the process as possible. For example, hit in the rear motions on a motor vehicle accident cases, they're often granted. Once a motion for summary judgment is granted, now you have interest running on the case. And as a defendant, if you're not going to see a trial for another 5 years after that motion is granted, now whatever the verdict is, you're paying 5 years of interest on it. So you have to value the case that way. And you're still going to probably save money by resolving the case earlier in the process than waiting until the eve of trial.
And because the plaintiff might take less to have a certain sum earlier in the proceedings, and that it cannot be overturned by an appellate court.
Well, I think we'd all agree that $10,000, $100,000, $1 million is worth more today than that same number in 5 years from now.
I just want to remind our listeners that we're talking with Jennifer Herscovici. She's a neutral. She's an arbitrator and a mediator, and we're talking about mediation. And she's with National Arbitration and Mediation. And she's talking about how she, as a mediator, can help parties resolve their negligence case. And she acts in other cases as well, in cases from all over the New York area. They can be resolved over Zoom or in person. It's a simple, straightforward proceeding. And in more cases than not, it can lead to resolution. Jennifer, what other tips do you have for litigants, for attorneys, for insurance carriers on why their cases should be mediated, or if no one can agree on mediation, perhaps arbitrated, and how you accomplish that?
Well, the tips I have for when you do decide to mediate a case, I think the best tip I have is, and it may seem obvious, but it doesn't always happen, is come prepared to the mediation. And when I say come prepared, you should know your case, and you should have spoken to your client beforehand and know where your client is willing to go, and have your client at the mediation or available at the time of the mediation. It seems basic, but it doesn't always happen. And what I'll say about being prepared is this. When an attorney is prepared for the mediation, you're showcasing your ability not only to your adversary, but to your client as well. So, and to the mediator. So you're showcasing the fact that if this case doesn't settle, and the case does go to trial, or the case is, there are motions that have to be written and argued, and then whatever happens until the time of trial, you will be a formidable adversary. By doing that, you put yourself in a good position to get the case settled, because your adversary knows this is somebody who is going to give me a run for my money. Also, when you're prepared for the mediation and everybody knows, and everybody is prepared, not just the lawyer, but the adjuster and the plaintiff, et cetera, then what has to happen at a mediation can happen. So you don't want to see the negotiation process happen, and then, a plaintiff's attorney turns around and realizes that they don't have their client in the place they need to have their client in order to get the case settled.
Sometimes it can be done as a two-part dance. You can have a preliminary hearing, educate all the parties about the possible scenarios and outcomes and parameters, and then everyone digests that, maybe does some further research on some of these issues, and then come back to you at some point down the road so you can bring them to resolution.
So we like to get the case settled on the date of the mediation. However, that doesn't always happen. So for me, what I try to do is if I can't get the case settled on the date of the mediation, and there's oftentimes reasons why you can't, I will either have the attorneys schedule another mediation. That's right. We could do it part 2, part 3, however many times we need to come back to get the case resolved, as long as the parties are committed to trying to do that. Or what I do is I follow up with the parties after the mediation, whether it's a week after the mediation or a month after the mediation, and see if they've made the headway necessary to get the case settled.
So a case has to be ready for resolution, and when it does reach that ripeness stage, you can work your magic and bring the parties to agreement.
Absolutely.
Jennifer, give us your contact information and more information on how to reach National Arbitration and Mediation.
So NAM's website is www.namadr.com. On that website, you'll find the telephone number, and I think you could submit a case through the website and you could get in touch with NAM pretty easily.
And you're on the panel of mediators or arbitrators. You can do it through Zoom. You can do it out in Long Island, in New York City, wherever they want to go if they want to physically go somewhere.
That's right. I'm happy to appear physically for a mediation or an arbitration, and I have done tons of virtual mediations and arbitrations, and they work really well as well. And
just recap very briefly again, if someone has a tort case, perhaps it's a new tort case, an accident case, or perhaps it's from before COVID, why they should resolve it now through mediation. Like I said, it's the most efficient, effective way to get a case resolved. And I think that the parties have control when they use mediation, and everybody comes out, in my opinion, a winner. You may not have the exact resolution that you want to have, but everybody comes out happy because the case was resolved. And you have something you can live with. And if you're a defendant, it's within your insurance coverage and you can move on. If it's within the plaintiff, you're getting your compensation sooner rather than later, and it's a certainty. Absolutely. I'd like to thank Jennifer Herscovici. As you've heard, she's a mediator and also an arbitrator with NAM, for being our guest. Their website is namadr.com. If you missed any portion of this show, you want to tell someone else about it, just go to our website, nccradio.org, and please join us next week at this same time for another program on Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York.